Briefly, somebody asked about this last night, and we'll get into it more on the Sunday show, any update on the Nick Rekieta case. And just a brief update. So there's 3 updates. First update, some people may not have heard at the time. Rekieta got all of his kids back, which, by the way, means that all the people drawing the most lunatic allegations against him or believing in a hair follicle test were embarrassingly wrong. That if people claiming he was drunk all the time must have been wrong. People claiming he was abusing drugs at an extraordinary rate must have been wrong. Because if they had produced any evidence that he'd failed a drug test or failed an alcohol test, if they'd produced any evidence that he had ever had the kids in custody in the car showing while he was intoxicated under either a drug, a narcotic, or alcohol, he would not get the kids back at this stage, at this time, at this pace. If, in fact, his kids had ever consumed drugs in any way, shape, or form, or been in the physical presence of those drugs, he would have not gotten his kids back. So it means there was no evidence that he had done any of those things that people had drawn conclusions on based on one report from one hair follicle test and the absurd allegations that the cop put in his report of repeating hearsay. So, there were many reasons to distrust that information out of the gate. Some people that hate Rekieta ran and rushed with it and embraced it. And then all of the frauds and fakes and phonies on LawTube ran to embrace it. And it's just laughably absurd. Nate the lawyer should just go back to being a crooked cop because that's the only thing he's good at. And legal mindsets turn out to be a complete fraud. The other weird thing with this is how many people turn out to be either connected to, affiliated with, obsessed about, or themselves deviants and perverts. Like the main guy who was trying to get into the files that would show the kids, the video files, the first person that did it, turned out to have a conviction for child porn. If you follow your instincts on these things, you could tell that those people were freakish people and had bad incentives that were seeking that information. Could tell that LawTube was being dishonest and intellectually dishonest and otherwise dishonest about how they were interpreting information. That the cops' report was blatantly unreliable. And we'll get to the bridge of the next 2 issues. He's also brought a challenge on 4th, 5th, and 6th Amendment grounds at this stage of the case. You have a lot of state courts they have something called an omnibus motion. And what it is a lot of your motions to suppress or anything like that, your certain 4th Amendment rights, 5th Amendment rights, 6th Amendment rights, you have to bring right at the beginning of the case. But there's procedures, a stage of cases, a sequence that you typically go through. And in the 4th Amendment context, it's a search warrant context, you often don't start off with seeking to suppress the evidence for trial. Instead, you want to make certain evidentiary findings that then can lead to that. And it's commonly and colloquially called a Franks hearing because of a Supreme Court case, Franks versus State of Delaware. And what that is there's 2 ways to review a warrant. One is to review what the judge did. And there's information that's developed on that, by the way. I mean, like pretty much almost everything I had predicted is proving true. And I just did it based on the initial disclosure of a limited subset of information. But if you've been around these cases long enough and you have enough familiarity with how these people act, you can predict at a very high rate what's likely to occur based on what is or is not present in the initial and original information you get. If you're any good at it, then you should be able to do that, to be frank about it. It's a way to test people to see whether they're really good at it or not. If you're reviewing the judge's determination, then you look at the sufficiency of the warrant itself. There you're just reviewing the judge's decision. And that's one set of standards. The other is you review the cop's decisions. And a Franks hearing doesn't ask you to question the judge's decision. It asks you to question the cop's decisions. Did the cop disclose all material information available to him to make sure that the judge could have reliable, trustworthy information for the determination of authorizing the search or seizure of someone's home or property or person, right? Or in this case, all 3. And the key access to that is they impose not a duty of diligence, though sometimes that's implied depending on the circumstances. My view is there should be an imposed duty of diligence on a law enforcement officer before they seek the search or seizure of someone's home, person, or property. But what the courts have done, particularly the Rehnquist court, which has tried to gut the Fourth Amendment every stage it could because of these originalist conservatives, note quotes, because that's what they're statist. They're just right-wing statist. But even under their efforts to try to minimize and limit and restrict and gut the Fourth Amendment, even under those limited standards, what they've said is there's no duty of diligence on a police officer, but there is a duty of honesty on a police officer. He can't lie. He can't mislead the court about anything that could be material to the warrant. And 9 times out of 10, anything in a warrant is material to the warrant because that's why it's in there. So one of the things I had said was that I didn't think the court that signed the warrant had done a thorough, comprehensive, diligent review of the warrant to see if it was constitutionally sufficient for such a broad search and seizure of a SWAT team raiding a family's home knowing the children are inside. In fact, guess how long it took the judge from the time the warrant was signed by the police officer for the judge to sign the warrant, right? Just from signature to signature. And this is available because they've been able to get the digital evidence on this. Take a wild guess. How long it took the judge from the time the cop signed it, not the time the cop submitted it, the time the cop signed it, till the time the judge signed it. 5 minutes is the guess. You would have gone over 4 minutes. 4 minutes. Just try to read that warrant application in 4 minutes. I mean, that's how ridiculous. The judge did no review. I was exactly right. The judge was a rubber stamp. Oh, it's a search of the local lawyer who has been blasting me publicly in this small town for the last year. Rubber stamp, rubber stamp, rubber stamp. That's what happened there. Proven right, once again. Then you've got what he's brought is what's called a Frank's challenge, and it's requesting the court schedule an evidentiary hearing. And it's very difficult to get typically in state and federal courts. It shouldn't be. It should be easy to get, but it's not because our judges are so deferential to prosecutors and police. However, like I said, there were red flags right off the gate reading that first application. And I just read what he'd submitted to the court before. Now, I didn't even read the search warrant application yet. I just read what he put into the judge to justify the detention. And I was like, there's all kinds of things that should be here that are not, that are assigned. This guy probably lied in the search warrant application. Voila, he did. We'll get into what he lied about, how often he lied, how frequently he lied, how consistently he lied in the Sunday show. The other component of that is I had said that I thought there were Fifth and Sixth Amendment issues, likely with how they tried to secure testimony from various people seized at the scene. And one of the co-defendants arrested was in fact Mirandized. She said, "I'm not going to talk until my lawyer is here." And I brought up that in fact at that point, as a cop, you have to respect, even if that lawyer's Nick Rekieta, you have to respect it, even if you think they're co-defendants. And of course, another cop, knowing that, came up and interrogated her anyway, and tried to get a bunch of statements against her interest. Now, if you've been following any of the losers on LawTube, you would have thought that all of these motions are completely baseless, have no foundation, or Hail Marys, have zero chance of success, are preposterous and frivolous, and not well written, and all that garbage. In fact, they're very well written, and in fact, they were so convincing that on the Fourth Amendment issue, rather than schedule oral argument, the state requested more time to file more briefing on the case, which, by the way, they don't commonly do. They only do that when they know they're up against it. And on the Fifth and Sixth Amendment issues, they completely conceded and agreed that in fact there'd been a Fifth and Sixth Amendment violation of the case, and that they would not introduce any of that evidence out unless there's been a waiver by the individual whose rights were violated. And people misunderstood the uncivil law should just stick to patent law. Didn't understand the confrontation clause, which you run into that at a disturbing level in criminal cases, even criminal defense lawyers who get it wrong. But it's striking how they got that wrong. But they're all predicting everything was going to be dismissed out of the gate, all going to be denied, all frivolous, all ridiculous. And instead, we already won on one major issue. We're really already won in terms of getting his kids back on the underlying facts, already won on the Fifth and Sixth Amendment violations that have been litigated to date, and already at least partially won in getting the government to need more time to file more briefs about the Fourth Amendment Franks issue. So so he had good news on that front. But it's a case that just has a lot of core constitutional issues at the front. And a lot of the people who jump to conclusions about him should be ashamed of themselves. All right. Aside from deciding to bastardize and ignore the Constitution because people decided they hated Nick Rekieta, people who drew the worst possible conclusions about a person they didn't know based on allegations from very dubious sources and various dubious conclusions from that information should be ashamed of themselves. It was ridiculous. It really was.